I'm Karen Friedman Agnifilo from Mistrial and Legal AF, here to bring you breaking news that the Manhattan DA's office is sending a letter to Judge Merchan saying they're not going to oppose if Judge Merchan decides to postpone the sentencing. It's kind of big news from the Manhattan DA's office, but it just goes to show what we've been talking about for years now about how prosecutors operate. There is a complete separation between politics and prosecution, and they follow the facts wherever they lead, and they follow the law. They do it without fear or favor, meaning they interpret the law as they see it. And so if it turns out that it's not exactly how we would all like, for example, to have the sentencing of Donald Trump occur on September 18th, as we had all hoped, this is how they play it. They play it down the middle. It is the opposite of a political persecution, which is what Donald Trump likes to say. So I'm just going to read to you the letter that was written. It's dated August 16th to Judge Merchan. And it says the letter addresses defendant Trump's August 14th, 2024 letter requesting an adjournment of the sentencing date. And the people defer to the court on the appropriate post-trial schedule that allows for adequate time to adjudicate defendant's CPL 33030 motion, which is the post-verdict motion pre-sentence, right? While also pronouncing sentence without unreasonable delay. To assist this court, we note the following points. So I just want to point out that them saying that we defer to the court on the schedule is essentially signaling that they recognize that there might be a reason to delay the sentence and they don't oppose it. And it's kind of giving the court permission to do this. So it's a little bit, I mean, to me, this is like they're consenting to an adjournment because that's how I read the letter, but that's the specific language of what they're using in order to signal to the court that there's a reason to delay it. And if the court chooses, they're not going to oppose it, that they defer to them. So it says in the letter, defendant's letter indicates for the first time his intent to seek interlocutory state or federal appellate review. What that means is what they're saying is the defendant, Trump, for the first time says he's going to appeal it midstream. So he's not going to, for example, if you look at there's two kinds of appeals. There's appeal after the final adjudication, which would be the sentence. And that's the appeal that every defendant has of right and that they always do or typically do to the appellate courts. There's something called an interlocutory appeal, which is an intermediate appeal. It means an appeal during the pendency of the case or before a sentence is pronounced. And that's what they're seeking to do here. They want to appeal, Trump wants to appeal Judge Merchan's ruling or rulings on the presidential immunity issue that has been brought up. And if you recall, Judge Merchan is going to be rendering his decision on presidential immunity September 16th. And so that's 2 days before the sentencing. So by Trump saying they're going to appeal it, what they're saying is we're going to appeal anything that happens between September 16th and September 18th. Given that schedule, obviously it would be quite tight and difficult for the judge to then sentence on the 18th. That's what the prosecution here is saying. They're going to, why they say, okay, judge, you can do what you feel you need to do here. So it says, defendant's letter indicates for the first time his intent to seek interlocutory state or federal appellate review before he's sentenced of any adverse ruling on his motion, this presidential immunity motion. It is correct that the denial of immunity from prosecution is immediately appealable. So one of the issues here is that presidential immunity is one of those things. There's only a few things, but one of the things that is appealable midstream or interlocutorily, the way Trump is signaling. And so that ties everybody's hands. What's unclear, however, and what the letter goes on to talk about is we're not talking about full-throated presidential immunity that is at stake here. Because if you recall, really the only issue here isn't whether the paying the checks was was part of his job description, is paying the checks to Michael Cohen, was part of his core presidential duties, and therefore he'd be immune. What's at issue here, and I'm going to read from this letter because they put it perfectly. It says, it is correct that the denial of immunity from prosecution is immediately appealable. But here, in contrast to the defendant's criminal case in Washington, D.C., the question of defendant's immunity from prosecution is not presented. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from official acts immunity, and if so, whether any error in admitting official acts evidence was harmless. So the evidence in this case that they're talking about is these small slivers of evidence that was put in at the trial that Trump is arguing was not permitted because of this new classification of evidentiary presidential immunity, and whether that's appealable interlocutorily. That's unclear, and the Supreme Court did not make it clear. But because it's unclear, and because this is new, and because what's going to happen here is whether this small subset was improperly admitted in light of this new evidentiary rule from official acts immunity, the court is going to have to discuss whether or not that was harmless error. And so the Supreme Court's recent decision, I'm just continuing to read from the letter, did not consider whether a trial court's ruling on that distinct evidentiary question is immediately appealable, and there are strong reasons why it should not be. Nonetheless, given the defense's newly stated position, we defer to the court on whether an adjournment is warranted to allow for orderly appellate litigation of that question or reduce the risk of disruptive stay from an appellate court pending consideration of that question. Assuming the defendant seeks an interim stay of the sentencing hearing immediately after the court's September 16th ruling, the people respectfully note that an appellate court considering such a request will understand that without an interim stay, it would have to receive briefing and decide certain issues of first impression in one day. The people are prepared to appear for sentencing on any future date the court sets. The people are also mindful that significant public safety and logistical steps by multiple agencies are necessary to prepare for court appearances in this matter. The defendant's newly stated position concerning an immediate appeal of his CPL this post-verdict motion ruling may mean that significant preparatory steps are taken only to have such steps disturbed by appellate litigation. None of defendants' remaining arguments merit any consideration. First, although couched as a scheduling request, defendant re-raises for the fourth time a recusal grievance based on false claims of a potential conflict that have already been rejected over and over by this court, by the First Department and the Advisory Committee, and the defendant's ostensibly new argument about the court's family members' co-workers' tweets is bizarre and has nothing to do with the post-trial schedule. I love it because it's like the Manhattan DA's office is calling him weird because he is weird, and I love that they're doing that. Anyway, the other thing they say about the defendant's concern about a public sentencing submission from the people is also misplaced. Any pre-sentence memorandum the people submit would be sealed, and the only way it would become public if the court orders otherwise or the defendant unlawfully discloses it. And that's because it remains sealed until sentencing, because obviously that could prejudice that could prejudice things potentially. So they keep it sealed until sentence. So, and then it says, finally, defendant's apparent insinuation that state prosecutors are incapable of applying federal constitutional law is fundamentally flawed, given that the people in this court protect and apply federal constitutional rights every day, which is true, search and seizure and all those things that we all do every day. Anyway, so based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule, signed all of the prosecutors on the case. And so there you have it. I think what that means to me is that the judge will still rule on September 16th on these issues, but I don't think he's going to sentence Trump on the 18th. I think what will happen is the the judge will give some time for this interlocutory appeal. And there you have it. On the positive side, if it does get postponed, I think there is a light at the end of the tunnel here, in that all of Trump's criminal conviction, prosecution, all of those things tend to actually help him, it seems, from a fundraising perspective. And it also gives him tons and tons of free airtime, since all the media, all they do is cover this stuff. So I think things are going really well for the Harris-Walz campaign. I think things are finally about the issues and about the campaign. And so I do think that rather this does have the added benefit, hopefully, of not giving a boost to his campaign, although it does show that the prosecutors aren't thinking about politics or thinking about the election cycle. All they're doing is looking at the law and applying it to the facts of the case, no matter what your name is, even if it's Donald John Trump. So there you have it. The sentencing, I don't think, is going to happen on the 18th. The prosecutors are being very appropriate and basically giving permission to the court to do what they need to do. But I do think we're going to see the judge rule on the evidence on the 16th. So there you have it. I'm Karen Friedman Agnifilo. Join us every Wednesday and Saturday for Legal AF, but more importantly, don't miss Mistrial. Mistrial is a new podcast by myself and Danya Perry and Kathleen Rice. We're all former prosecutors, state and federal, and Kathleen Rice is a former member of Congress. And you get an entirely woman's perspective on these things and former prosecutors' perspective. So join us every Thursday.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.